Presentation, Wills and Directives. I'm hosting with Allison Schaberg of the Consolidated Planning Group. She's a special needs financial planning consultant who lives the life that she also works. And our guest speaker today is Boyd Handley. He is also a dad of a special needs child and a special needs attorney. And at this time, I'm going to hand it off to Allison to facilitate the meeting. Thank you all and welcome.
Thanks so much, Jacqueline. Thanks for having us back. We're happy to be here with you today again. And so as you said, I'm Allison Schaberg, Consolidated Planning Group. We are here today back again with Boyd Handley with the Handley Law Office. We're excited to have Boyd here today. Boyd and I work together a lot. We kind of talk about the various topics as it relates to special needs. And one topic that comes up all the time is why do I need it? What's the difference between a special needs planner and a special needs attorney, basically? I think Boyd probably gets questions all the time about the financial matters, and I get questions all the time about the legal matters. And the interesting thing is when it comes to special needs planning, it's kind of siloed. And I always use the term that, he's the legal in the legal documents, he's the paper, and I'm the money. And so we got to have both. Both of those things are really, really important when it comes to planning. So today we're going to be talking about, are you prepared? Thinking about things, wills, probate, other planning documents that you might need to have in place. And we are kind of the mindset of kind of doing it ahead of time. But, I think what happens is a lot of times things happen in life, unexpected events, maybe with a family member or a loved one or something like that. And then it has a sudden urgency that we need to get this done, although we haven't had it done in a long, long time. So if your documents, A, you don't have them, we're glad you're here. B, if you haven't had them updated or looked at in a really, really long time, we're also glad you're here. And if you're just trying to figure out where to get started, I think this is going to be a good place for all of you. So today's meeting is being recorded. We will send an email out later today or tomorrow with this recording and the slides and contact information, everything like that. We do have a YouTube channel where these recordings live. So if you miss one or if you want to look at other topics that we've had in the past that might be relevant to your situation, you can check that out there. We do want to answer as many questions as we can today. So if you'll put your questions in the chat box, we are going to monitor that. And I've got 12:03 and we will be done by 1 o'clock. So if you're on your lunch hour and you're wondering how long this is going to go, we will be done by 1 o'clock today. So Boyd, having said that, I'm going to turn everything over to you.
Well, thank Allison and Jacqueline. Thank you for inviting me here today. As you see on the screen, we're going to talk about will, probate, and other planning documents, and really throw a lot of things at you, at least the terms where you can think about it after the presentation. Unfortunately, I have to give you a disclaimer. This presentation does not create an attorney-client relationship. And also want to let you know that this is just general information. Each of the materials that I'll talk about today or documents are different, and each person has a unique situation where there's different ways of doing things. So please don't take this that Mr. Handley had said you could do this. That may be where, depending on your situation, things can be very different. Why do you need a will? Well, as we all know, the will distributes what you want to your loved ones. If you die without a will in Texas, the state's going to tell you who gets your assets, called intestate succession, which is a crazy, mixed up way about going about it. It gives things to your spouse and to your kids, and then if your kids are not around, it will go to your parents and things of that nature. So you really need to have a will where it will distribute assets to who you want, and especially if you have special needs children or children with disabilities that get government benefits, because of course, as you all know, they can only have, once they turn 18, they can only have $2,000 in assets. And if they do get an inheritance, it could cause problems. Now, there are ways that we can take care of those assets, but in court prior to the court getting out of probate. But in a lot of situations, the family loses control and the court oversees some of the trusts that we can set up. If you have a blended family, such as you've got in a second marriage, you've got kids from the first marriage and kids from the second, your spouse has kids from a previous marriage. If you don't have in your will who your assets are going to, in Texas, we're a community property state. What that means is that any assets that you acquired prior to your current marriage or separate property, and then assets that you required during your marriage is community property. So don't think that if you're in a marriage with a blended families, if you haven't adopted one of your spouse's kids, that they may get some of your assets if you want to give it to them. So you really need to mention who you want your assets going to, because if you die without a will, your kids from your blood kids will get their portion, and then any of your kids from your friends or even kids from your current spouse will not get any of your property. So you really need to think about that. If you've got minor children, you need a will to name who the alternative guardian is if you and your husband or the biological parent of your kids die in an accident. If you don't have this, then the state will also determine who in your family is the best person to get. They'll go to the grandparents first, and then go down to siblings, and then down the road, aunts and uncles. You may have a set of great parents, but one grandparent may be better than the other in taking care of your child with special needs. So that's needed. If you've got a will and you don't have the guardian in it, we can put a separate document to the side naming this. The way that works, if you do both die in an accident, then whoever you're named as the guardian will take your will, your death certificate, and go to probate court and get named. I've done this a couple of times and it's worked very smoothly. Types of valid wills in Texas. If you've got an out-of-state will, if it was valid in the state and it's called a foreign will in Texas, if it was valid in the state that you had it drafted in, it's good here. And then the other thing with an out-of-state will or even an in-state will, if you want to make changes, a lot of times you don't have to make total changes. You can do what we call a codicil, which is an attachment to the will. And it's a lot cheaper than making changes or getting a new set of wills. Holographic will is a handwritten will in Texas. It must be in the person's handwriting, signed by the person, and it would be great if you've got two witnesses to testify. Unfortunately, those two witnesses can't be family members. They have to be someone that it's not going to gain from your death and your assets, and just do that. But those wills will hold up in court. Online wills, you can do that, but be careful. Just be sure that you have and understand what you're signing, and be sure that everything's done correctly. I do support attorney drafted wills. They can be customized to your needs, and always very important. Of course, requirements for a will in Texas, you must be 18 or older. Age of 18, you become an adult. You must be competent. That comes into a lot of situations where you've got elderly people that may be redoing their wills. And will must be signed by you in front of two witnesses. And then those witnesses, of course, have to be over the age of 18 and has to be signed in their own handwriting.
Boyd, I've got a question, and you hit on it a little bit on the do-it-yourselfers, the DIYs, because I do get questions about that on a weekly basis of, can I do this myself? Can I download, my own documents or things like that? And I am a fan of stick to what you know and hire the professionals to stick to what they know. That is my general advice. And generally the families that we're working with are special needs families, so they have a specialized situation, which I think warrants professional, professional advice. I want to know, because I mean, some families need to save money or they want to save money, and that's why they're thinking about doing it themselves. So what are the issues with that? What are your thoughts on that?
Well, the issue is if you've got minor children, you should have a contingent testamentary trust in your will, because minors in Texas cannot own property outright and or have bank accounts in their own name or get funds from someone that had given them funds during the death or something. So in all my wills, I have a contingent trust for anyone under the age of 18. And then in that trust, you can tell them how you want it distributed, such as between 18 and 25, pay for food, lodging, college, car, an apartment, 50% at age 25, and maybe 50% at age 30. If you die, regardless of how well you've raised your kids, you wouldn't want an 18-year-old getting a lot of money or other assets at age 18. And contingent testamentary trust. A testamentary trust is a trust that becomes valid at your death. So you can do that. We're going to cover trust shortly. The other thing is a guardian. Again, as I mentioned, you need to have a guardian named in your will. If you've got kids with special needs, I would say a testamentary special needs trust, because again, you have to be careful with your loved ones getting any assets over $2,000. So those three things are very important, which you're not going to get in a will from online. And if you've got a blended family, again, I wouldn't do online will.
Thanks for sharing that, and I'm so glad that you brought up the testamentary side of the house. And I know you're going to go deeper in that, because I think we eat, sleep, and breathe these topics, and we throw these words around. But when somebody hears like a testamentary trust, and you're saying that this is it kind of lives in your will, and the trust is actually formed upon your death. So this is where you don't have a trust with the tax ID number while you're alive, but when you die, that's when it goes. And the whole point of that is, in that example, like say a beneficiary is 18, they can spell things out in a testamentary trust of when and how they're going to get the money. Whereas if it's just a beneficiary that's 18 or is a minor, they're just going to get all the money. That's and correct. And they can do whatever they want with it. And history tells us that that's not good. It never ends well. So that would be the reason behind that, huh?
Yeah, absolutely. I think we discussed a lot of these. You definitely don't want your assets distributed by the way the state will tell you. We mentioned blended families for sure. Minor children, you definitely need to take care of them in your wills, and especially if it's special needs or disabled children that will possibly get SSI and Medicaid at age 18. Medicaid has a 5-year look back, and Social Security has a 3-year look back. So if you die within those ranges prior to your children turning 18, then you need to take care of those assets with that. And then if we'll go over this also, if you die without a will, then you've got to go through some jumps as far as probating your estate, and you can spend a little bit of money now, which will save you a lot of money down the road. All right, going the wrong direction.
One thing that you mentioned that I think is real important, as far as the state appointing a guardian, I mean, a will is doing a lot of things, but having decisions made as opposed to people that, I mean, granted, guardian ad litems and all these other things come into play and stuff like that. But the bottom line is if you don't make choices are made for you in the event of, an unexpected death. And so, especially if you have kids, it's so important that you have this written out, so there isn't a court that's making these decisions with children that are clearly upset at your loss.
Yeah, that's very true. You know, I mentioned that kids under age 18 cannot get own property or have bank accounts without the parent on it. About a year ago, I had a parent that died unexpectedly, and they didn't have a special needs kid, but they had a life insurance policy that was directly to the 7-year-old child, and it was like $250,000 actually, and there's four things that happen in Texas when a minor inherits property uh, in this situation. Uh, First, it was a life insurance policy. So the mother called the life insurance company up and asked, "Can I get this money for my son?" Well, they said, "Well, the son is underage." So there's four things you can do. You can go to probate court and get guardianship of the estate. And once you get that, then we'll give you the money and you can put it wherever you want to. At age 18, the young person will get a $500,000, or you can put it into a UTMA account, which is a underage account that's for underage kids in Texas. And that in Texas, that goes until age 21. So again, the child is going to get $500,000 at age 21. Luckily with those, we can move though, if the child is disabled, then we can move that to a first party special needs trust prior to the child turning 21. But it just shows you that if the father had put a name, have a contingent trust in his will, he was an expat, so he didn't even know about it. Even though the child is not disabled, then that money would have gone to that contingent trust, and then the other parent could have gotten that money out and used it for her son. So it's just things like that, regardless of whether you've got a child with special needs. If you've got a minor child in Texas, there's a lot of things that take place with that. You've probably looked at this community property and separate property in Texas. That has a lot to do with how your assets are distributed at your death, and we'll go over that here shortly. I've talked about intestate succession. If you die without a will, I won't go over this a lot, but it's some crazy stuff. Like if you've got a spouse and kids, your community property is property that you've acquired during your marriage. Separate property, if you acquired property prior to marriage, that's your separate property. If you die without a will, your spouse gets all your community property and 1/3 of your personal property, and the right to use your estate for life, and the kids get everything else. So spouse with kids from another marriage, spouse gets 1/3 personal property and right to use your real estate, and the kids get everything else, including your 1/2 community property. And that just will create a ton of problems. So please have a will and have it done and tell the state how you want your assets distributed. We've got diagrams on intestate succession, and it's just absolutely crazy with how it comes about. You also need to know how a child is recognized in the state of Texas. Adopted kids, thank goodness, is treated as a natural born child. If you've got a mixed blended family and you don't have a will, then your foster children or your stepchildren will get none of your assets. And even if you've got a child that's been placed for adoption in the past, in a lot of cases, that child still is heir to your estate. And of course, children born outside of marriage, you'll have to have a test to do that, but they can also come back and against your estate and file for that. But we won't go into a lot of this. We've talked about a lot of reasons for a will. It's really the way that you distribute your assets to your loved ones or friends, and instead of having the state do it, which may not be the way you want to go about it. We've talked about a testamentary trust. As Allison mentioned, that is a trust that stays dormant in your will until you die. And then what happens is your executor takes your will. It has all the steps and things about what the trust does and how the trustees use the trust. And he takes that with your death certificate and goes to a bank and opens up a trust fund, or can go to a Fidelity account and open up a Fidelity account and put the assets in for whoever is the beneficiary of that trust. If you don't have that done, then your assets could be tied up in court for a period of time. Probate in Texas is very easy, but I've had some very simple probates that have gone over a year and a half just getting everything done. So it can be very frustrating with your family if you don't plan ahead of time. The good thing, if you're divorced and you have an old will with your ex in the will, the way Texas looks at divorcees is that if you're divorced, then it considers your ex as deceased in your will. So you're okay there. The issues with that, if you've got some trust, then the trust in some cases will trump the will. And then if you've got the beneficiary named in a life insurance policy or a 401k, then that's going to trump the will also. So just be aware of that. But if you've got an old will from a previous spouse that's divorced now, then you're okay with that.
Someone asked a question, Boyd, and said, should you fund a trust prior to your death or allow the trustee to fund the trust? Is there a right or wrong answer for that?
All my trusts are irrevocable. So what that means is that once you put money in, you can't take money out. And I tell parents that when you want to fund a special needs trust, or most family trusts are revocable. So you can take trust, assets in and take assets out. All my special needs trusts are irrevocable, because I basically tell parents is that if you don't want to fund it, don't fund it. If you think you're going to use the money or need the money or assets later, please keep it out. I personally have not, my parents prior to them dying actually funded a little bit of money in my trust. I personally haven't funded mine yet. At my death, of course, everything goes to my spouse or vice versa. And then if we both die in an accident, then everything goes to my daughter's special needs trust. So that's how we do it. And that's actually how I tell clients to do it. You have a lot of grandparents that are giving kids special needs or disabled kids stuff, and that can go into a third-party trust. And because it's for the kids, and you're not going to can't take money out and use it for yourself. So that's how I set up my trust. It's just a philosophy. And then you're guaranteed that SSI will not count it as an asset if it's irrevocable. Now, there are some special third-party trusts that are revocable, but I don't take that chance with mine.
So we had another question about, can life insurance and retirement accounts be integrated to a will or special needs trust so the SSI benefits are not impacted? And Boyd can answer too, but yes, life insurance is often, we find life insurance proceeds often funding a trust. So a trust may have $5 in it, and it might be funded upon a person's death. That is definitely a path, and that is the right way, as opposed to naming your special needs loved one as a beneficiary outright. To leave those assets to that special needs trust. But do you have some additional insight on that, Boyd? I mean, I think that's kind of this age-old question of, do I fund it now or fund it later? And that's part of the money side that we work on, of how do I fund my retirement for 25 to 35 years and make sure that there's still enough money to fund future care for my loved one for 20 or 30 more years. So I think it's a big question.
Yeah, that's definitely where you come in, understanding what it's going to take for these kids to live down the road. And from my standpoint, there's three things that are outside of probate. There's retirement funds if you have a beneficiary named. There's life insurance policies if you have a beneficiary named, and savings and checking accounts if you have POD, payable on death, named on those. And basically what I tell clients and what I've done in mine is that, of course, I've got everything going to my wife first in my retirement and life insurance. And then I have my daughter's special needs trust name as the secondary beneficiary. So that's how I've got it set up. Now, you know, there are, with retirement funds, there are some issues with taxes. I'm not a tax attorney, so I tell clients to see their CPA. If they can't help, then I can get them a tax attorney. And then we had, of course, the Secure Act done a couple of years ago, which has changed the when all this money has to come out of these retirement funds. So, you know, I personally don't worry about that. Everything's got to go there whether I want it to or not. And but you may have some parents that really want to understand that. And, you know, that's something to definitely talk about. But I personally say, you know, there's really no need to fund those trusts now. I would have them set up. And if you have family members that may give your child something at their death, then definitely have a special needs trust on the outside, which is what we call a third party special needs trust, which is a trust from someone else's assets. And then, you know, if your child has had a lawsuit that he or she has won, then that money has to go into what we call a first party special needs trust. And we're going to get another slide on trust, and then we'll go over the Medicaid payback and stuff once I get on the slides of trust.
But that would, so like in that example, so there's the difference of a first party and a third party special needs trust. But in that example, that first party trust, if you had a first party trust, so in my example, my daughter does have a first party and a third party trust, and there is money coming in directly for her, so it has to go. So in that example, that first party trust is funded. But another thing that you said, and I want to repeat this because this happens, we see this a lot, where we have grandparents or other family members of affluence that might be getting older that have money that they want to leave to the special needs individual. And so a question that people ask on a regular basis is, if grandma is going to leave money to little Johnny, can she have a testamentary special needs trust, or do we need to already have a special needs trust? So like if you've got mom and dad has a will and they have testamentary special needs trust under the confines of their will, but grandma's leaving the child money, then what needs to happen?
You can do it both ways. In my situation, my mom changed their will saying it's going to the third party special needs trust. We just had one on the outside to make it a lot easier. You can have as many third party trusts as you want. You can only have one first party trust. So in divorce situations, each of the parents can have their own third party special needs trust and have the assets of their family in that. And then that, of course, goes to their beneficiaries at the death of the child or adult, hopefully down the road. The only issue, and I'll get back to the grandparents' will, the only issue that I have is that once you get so many special needs trusts by different people, and those people may not be talking to each other, you have to be sure that money is not spent on something that the trust can't spend it on, such as SSI pays for food and lodging. So you cannot spend trust money on the food and lodging unless you put into an ABLE account, and that's a whole nother thing to talk about. As far as the grandparents' will, they can have a contingent special needs trust, and that will work. The executor of the will would have to set it up, but it would be a lot easier for them just to have the money going to a third-party trust on the outside. That way you'll be in control. You'd have to understand who your parents are putting as a trust, or the grandparents are putting as a trustee. So you'd have more control if you had it on the outside, but either way would work with that.
And I think we actually had this come up, and then I do have another comment. But the other week we had a client whose parent suddenly passed away, elderly but healthy, and it wasn't expected. And unfortunately, the will had not been updated since the spouse's death. And there were 8 like successors, and all but 7 of them were deceased except for one 88-year-old ailing family member. So, kind of readdressing and regrouping these things when you've had any major changes in your life, I think that comes up. One comment that we had is I was told that a third party could not fund my child's special needs trust. Is that true, Boyd?
Well, a third party can, you can move money to an ABLE account, but you wouldn't move money from a third party to a first party trust.
No, I think what the comment was, so you wouldn't move money from a third party to a first party trust, but I think what the comment was is basically that this individual was told that an outsider, so if your mom and dad, you can fund a trust for your kid, but basically other people could not fund a trust. So basically, can anybody put money into the trust of the individual with special needs? I think that's the question.
Yeah, I mean, a third party trust, you can name, if you know that individual has a third party trust, you can name that in your will, and then your executor would then transfer that money at your death to that particular named third party trust. It will work that way.
Well, let's use the example that grandma and grandpa, while they're alive at Christmas time, instead of sending a check to little Johnny, they want to put a check to the special needs trust. In that example, is that allowed? Grandma and grandpa want to retitle one of their vehicles to the special needs trust. Is that allowed?
That is allowed, yes.
Okay, got it.
That's basically what happens if someone wills it in the will, whether they're alive or whether they're dead. It's the same type principle. And that would have to go, of course, to the third party special needs trust. Yeah.
Got it. Okay. So the bottom line is anybody can put money into a special needs trust for the benefit of your child, which is also true that anybody can put money into an ABLE account. You can only have one ABLE account, but anybody can put money into an ABLE account for the benefit of your child as well. We've got some fee questions, which I'm going to delay. I do see them, and we are going to address them. I'm going to let Boyd continue, but we're going to come back to that as well.
Yeah, the issue with the ABLE account is that you can only put $15,000 in a year, so you really have to understand what money's going in. I do a lot of guardianships. If you've got a high functioning child with special needs, then you can do a power of attorney, medical power, and this is for your parents too. This is for your spouse. Everyone needs to have this one way or the other. Like for instance, if your child are going off to college, please have a medical power of attorney and power of attorney on them. It can be immediately or upon your incapacity. What happens is that once these kids turn 18, they're adults, and if they're in a hospital, if you don't have a medical power of attorney or guardianship on them, then you can't call the doctor and talk to them because they're adults. If they're in a coma or incapacitated, you're out of luck. And a lot of times you can't even call the hospital and ask if they're there and what condition they're in. So those documents are very necessary. And if you've got elderly parents, mine were very good. I was, of course, on their checking accounts and had the POA and MPOA on them. But you really need those, and you can tell your parents in a lot of situations they don't want you to get in their business. And we can draft in on their incapacity, and we can actually draft either 1 or 2 MDs to sign saying they're incapacitated, but definitely needed. If your parents get dementia, they don't have a medical or power of attorney or power of attorney, the only way you can do business for them is to get guardianship of the person in the estate. And that's no need in that. The HIPAA documents, they basically allow your loved ones to call the doctor up and get medical records on you. Physician's directive, sometimes called a living will. The way I tell that to parents is that, if you're in a bad accident, you're possibly brain dead and they've got you on a ventilator. Sometimes the hospitals take a long time to take you out of that, or whether you even want to be put on one. and you don't want your loved ones, your spouse or your kids making the decision on whether to pull the ventilator off. And this is one way of doing that that allows you to keep them from making that treatment. You've got one a child that wants to do it and the other three do not, and it just creates problems. And basically what we're trying to do is make it easy on the loved ones when we go later down the road. And of course, I've talked about POD, payable on death, on checking accounts. That will keep all your assets, all those checking accounts out of probate.
One thing that I would just mention there on your list as well, Boyd, is that one thing that we see with some of our aging parents is they still have a safety deposit box at the bank with a key. Sometimes you have all these keys and you don't know where they go. Find out if your parents have one. Many of our family members that are 80 plus do believe in like a safety deposit box. So, and that is something that maybe that you can be put on as, as a person that's allowed to access the box or things like that. But if you don't know, or you're not on there, or it's not specified, it can take a court order. And so we've seen, and I had one client years ago, she had like 20 keys. And she didn't live in the town, and she had no idea what bank it was at. It was horrible. It was horrible. She knew it existed because he spoke about it, but she literally didn't have any idea where it was. And so ask that question, mark that down to ask at least.
Yeah.
And that could go for grandma and grandpa or your own aging parents.
Yeah. Yeah. That's a good point. My parent, I was on there, they had a safety deposit box, and of course it's very easy to go in and get it since I was on their account. So definitely with the older generation. We've talked about a lot about the trust. We've talked about the testamentary trust. Trust can be revocable or irrevocable. Of course, my special needs trusts are irrevocable. Your living trust are revocable. A living trust is actually one that you can put your assets in now, and then at your death, then all those assets are out of probate, do not have to go through probate. Now, I tell I tell people if they're young and they're going to be buying houses and getting rid of houses, then a living trust is probably not the way to go. But if you're an aging person and you're down to your last or next to last house, then do not want everything public, because when you do probate your will, and a lot of times you have to do an accounting, and then all your assets are public. So if you don't want the public to know what you've got, living trust may be the way to go. We've talked about managing assets for a minor with a trust, and especially when your kids turn 18, you don't want them to get a lot of money. And then trust help to lower taxes in certain situations. And of course, I've just mentioned folks that may be reaching the point where they have to go into a nursing home. Of course, in Medicaid, we have the 5-year look back. We can actually put assets in a trust if we can do it ahead of time. And then once they get past 5 years, then they would qualify for Medicaid, which will pay for nursing homes. And we can do about that. Unfortunately, what happens most times is that, well, my mom's going into a nursing home in 2 weeks. She has a lot of assets. What do I do? And unfortunately, there's not a lot that we can do at that point in the game. Your house is not counted as a asset in Medicaid. But if you we can do some things with that, and then possibly spin down some of your other assets to get Medicaid compliant. And then a trust keeps someone from spending your inheritance quickly. You may have a child with special needs. Of course, we need to put that in a trust, but someone that may not be high functioning, but may not be on Medicaid or government benefits, and may not be very good with money. So putting that into a trust for them is definitely the way to go.
Hey,
Yeah.
Boyd, one thing that I want to ask on the like a family trust. So let's say, for instance, we have an affluent family. There's millions of dollars. There's a family trust,
Mhm.
and within the confines of their family trust, they can also have a special needs trust in there where the assets leave from the family trust to the special needs trust to fund the special needs child. Is that correct?
That's correct. I didn't draw this up, but I had a client about 2 years ago show me a family trust that was drawn up by another attorney, and it had 7 different trusts in it. And I said, well, it all looks good, but you need to ask that attorney how it actually works at the death, because there's so many moving parts and it looks great on paper, but how does it physically work? But yes, to answer your question, you can have a multiple trust within a living trust as far as how you want to separate the assets to various people. Mhm.
And so, so we talked a little bit about probate, and so you've got, so let's just say you don't have a trust, you have a will, okay? So if you have a will and you don't have a trust, so the reason you have a trust is to avoid probate. So that's the idea. So you have a trust, and then you've retitled your assets into the trust.
A living trust, not a trust in general. But if you've got a living trust, I don't personally have one. My mother-in-law does, and basically everything, she has her car and her house in that living trust. So that's all going to be outside of probate, and the trustee at her death can distribute that property to her beneficiaries. And then, of course, as I mentioned, outside of probate, if you got beneficiaries, your life insurance, your 401k, and your checking accounts with that. The other thing I like to mention is a right of survivorship. With a community property, in most cases, you and your spouse own 50% of your house. Even if your spouse has his name on the lien, if you're paying for that with community funds, then you own 50% of your house. And what happens, and we just did this with our house, a lot of times in the olden days, they did a right of survivorship in your deed of trust, which is with the lien on it. But nowadays they're not doing that. So if I died tomorrow and we had not done a right of survivorship, then my wife would have to go to probate and do some documents in order to get 50% off the house in order to sell it down the road. And but if you have a right of survivorship, then at your spouse's death, then your 50% of the house goes to him or her. And that's just something that you can spend a little bit of money now and will save you a lot of money and headache down the road. But no one knows about this unless they tell you, because the title companies will definitely not say anything to you. And now what I can't,
when do they need that, Boyd? I want to be clear on that. So in the example that a husband and wife are married and they have a lien on the house, and the lien is together. It's in both of their names, not just one of their names. Do they still need this, or when do they need what you're talking about?
At the end of the day, one spouse owns 50% of the community property, and the other spouse owns their own 50% of the community property. So the deed is actually split in half. And so if you've got this right of survivorship, then all you have to do is file the death certificate with the county, and then the deceased spouse's 50% automatically goes over to you. So if you ever want to sell the home down the road, then you've got clear title to it.
So this would be especially important in blended families when there might be his, hers, and our kids, or his and her kids. And this is where, if you didn't have that and you have a blended family and a spouse dies and their kids say, hey, wait a minute, half that house is mine, that's where it could be start to be a problem.
Especially if you die without a will, then
Got it.
The blended family kids are going to get that part of the community property. So now the spouse will have lifelong use of the house, but and of course her his 50%, but it's going to cause problems. A lot
I got
easier
it.
to do this. Yeah. The only other, yeah, go ahead.
One thing I want to say that is really, really important, and this is confusion really all the time, is people say, well, it's all spelled out in my will. When it comes to how things are going to be distributed. And you said this a minute ago, but I want to highlight this because it is super, super important. When it comes to life insurance, investment accounts, bank accounts, 401ks, 403bs, pensions, all of those things, it is governed by the named beneficiary on those accounts. So it is important from time to time to review your beneficiary designations and make sure that they are accurate, and that is how you want that. Because even if you've done this, even if you've spent money and worked with an outside attorney and you've got a new will and you've got a new trust and you've got all these documents and they're wonderful, and you failed to update the beneficiary on any of those life insurance contracts or investment accounts, the beneficiary is going to be whoever is named on those accounts. It's not going to be the will or the trust. So it's important that people understand that.
Yeah, I'll give you a good example. Dad has a 401 account, and it has mom on it. Dad dies. Mom doesn't mess with the account because it's in fidelity and making money. She doesn't need it. And then mom dies, and mom did not put a beneficiary on that retirement fund. Well, the kids or whoever is in the will have to probate that will, do a full probate in order to get that money. So, you know, as Allison says, update your beneficiaries when something like that happens. Mm-hmm.
For sure. I've seen horrible examples of ex-spouses and other things like that, where it's just kind of out of sight, out of mind. People got divorced or other things like that, and ex-spouses ended up getting the money, or ex-people that you would have wanted, you know. And so that's why it's super important. But it's super important to have these conversations again with your aging parents, with, you know, changing factors, death of mom or dad, or some of these things where just I would say that advisors, although they don't normally like call and nail people down and say, hey, you really need to do this. They rely on people calling them and say, hey, I'd like to update this or change this. And quite honestly, a lot of people just don't know to make that call. So it's not being crazy. You just don't know. So it's just super important.
Yeah. The other thing that I've mentioned is Medicaid estate recovery or Medicaid payback. If your mom or dad is getting Medicaid later in life and they don't have their homestead in a transfer on death deed or ladybird deed, and we can go into that. That's another story in itself. But there's a possibility that at their death, the state may come back and try to get the money that they've paid in Medicaid to your mom and dad if they're under that. And there's something called the transfer on death deed and ladybird deeds that we can do in order to shield that homestead at their death. So that's something that if you think your parents will be getting that, such as if they're in a nursing home and getting paid by Medicaid, that's something to think about. I know we're getting short on time. I wanted to go, what is probate in Texas? We've talked about how to keep everything out of probate or why you need a will. There's two different situations in Texas. You can die with a will or die intestate without a will. If you die with a will, you can go through a full probate, which will get you letters of testamentary, which will give your executor named in your will full legal power to distribute, sell, and take care of all your assets. If you only have possibly a homestead that you're trying to sell, and it's been less than 4 years, you have 4 years to probate your estate. If for some reason you don't do that, then you would have to file a monument of title. Both of these, you have to have a hearing, but that will allow you to transfer ownership of any real estate that you may have, and that's available. I did one of these a couple of weeks ago where you had a wife that died, and really the only thing that was needed to probate was her 50% of community property on the estate in order to sell the house. And so we were able to do a monument title. Um, if you've got, and if you've got, you know, your bank accounts, your life insurance, and your 401k with beneficiaries, that really helps when you have to go through probate, because it cuts down on things that you have to do. If you die without a will, then there's three things you can do. If it's just a asset such as the homestead, and the homestead, and you have no other assets, or less than 50,000 assets, you can do a small estate affidavit, which is only good to transfer title on your homestead. If you got other property, you'd have to go to an affidavit of heirship in order to transfer title to the beneficiaries. If you've got multiple properties, bank accounts that do not have beneficiaries named, then you have to do a determination of heirship. Basically, that's two different filings. Determination of heirship is you have to file that. The court will appoint an attorney ad litem to figure out who are the heirs to your will, although you may know who they are, and that's going to cost you some money. And then we'll have to also file the application for letters of testamentary, which is like probating your will. So when you die without a will and you've got a lot of property or things that you don't have beneficiaries named, you have to go through that. And that's probably going to cost about twice as much as probating your estate with a will. So, you know, there's different choices in Texas. You really need to talk to an attorney, even though you can get an affidavit of heirship from the county clerk's office. You really need to understand what's in that. I had a question this morning on one. You've got to have two disinterested witnesses to notarize it or sign it, but they've got to have some documents wording in that a lot of the title companies request, and the online form did not have that. So I was trying to tell the client that, well, you can save you money, but be sure you have this in there. So those are very complicated. Well, not complicated, you just got to know what you're doing. But those are your options in Texas if you die with a will and without a will.
And I think, you know, there's no question you do spend time and you do spend money getting this together. It isn't free, and we're going to talk about that. But the time and money you end up spending picking up the pieces of not planning, it is much greater. There's a lot of stress involved with it. And I've seen like colossal issues. Like I actually even had a justice one time that died suddenly and had properties in multiple states. Like nothing was set up, like nothing. And there was his kids and our kids and that kind of thing. And it took years. It took years. There were so many properties and so many things in different buckets that it just wasn't taken care of. And this was a person of high caliber in the legal system, and they themselves didn't have it taken care of, and their spouse really, really suffered. So I just, you're here today because you're curious about this and you want to know and what you need to do. So for sure. Boyd, we got about 7 minutes left, and one of the questions that always comes up every single time, and I always know that it's a loaded question, but we want you to give you a range. Like when it comes to doing, this type of work, if somebody just needs a will and maybe a testamentary special needs trust or something like that, what kind of money are they looking at spending? If somebody needs a full-on, extensive trust that we were talking about, and what if they just really need a special needs trust? Or maybe, can you just give some ranges so people can kind of budget for this?
Yeah, they can run a very simple will without any trust in it, without a lot of additional wording. They can run between 450 and 500 or so, up to 750. And then, if you add a trust to it, you're probably adding another $850 or so to that. So, you can get probably a will package with a trust can run between 1,500 and 2,000 that has all the bells and whistles in it to a certain degree. And then it really depends on your assets. And attorneys are very different in prices. But I think that's probably the low end. And it really depends on, I always hate to give numbers out because unless someone tells me their assets, what they need, it's really hard to give them a number.
Well, sure, and it matters if they're married or divorced or like all these
right.
other factors, and those things matter. But just knowing that at minimum you're probably going to spend a couple of $1,000s is probably a good place to have in your mind. I mean, I think that that's just at least a start. I think, we're all humans. We all like to know. It doesn't matter how much money you have. You like to know if I'm getting ready to drop money on something that I got to do, I like to know how much that's going to be. So I think that that's good. This is really a timely conversation, and I am just reminded over the years of how many stories of parents or stories of things people thought things were handled or they weren't, or, it was after a stroke, after mom or dad became incapacitated, and trying to pick up the pieces from that. And just the sheer stress of the situation at hand because something happened acutely is horrible, right? But then when you add in the stress of nothing was handled or nothing was taken care of ahead of time, and we've got a lot of issues as a result of that, it just compounds everything for sure. So we're just about out of time. And, this is, as always, these are, if you got a special needs child, this is just a bullet point list of things that really should be on your radar. As mentioned earlier, we do have a YouTube channel. We do put recordings out on a pretty regular basis. We partner with other professionals, other attorneys, other organizations that are really good at what they do. We put presentations out ourselves, sharing about what we do and kind of the methods behind the madness on these things. But if you're feeling overwhelmed, this was a lot. This was a deep presentation, and it's a lot of moving parts, but it's really, really good. But if you're feeling overwhelmed with all the things that you might need to do with a special needs child, and you've got a child, coming, into adulthood, or maybe they've already crossed over, this is just a bullet point list. And there are webinars on our YouTube channel on basically every single one of these topics. So you can go out there and hear those at your convenience. So having said that, let me just see. Okay, we do have a question about when a special needs child is 18, should he apply for SSI or SSDI? And so that is, we have many presentations on SSI and SSDI. In fact, I did one yesterday, but on our YouTube channel. But yes, they should apply when they turn 18 for SSI. Basically, they're going to apply for SSI and SSDI. SSDI is usually denied. SSI and Medicaid would be considered. But do find those out there on our YouTube channel. And Boyd, we've got Boyd Handley's contact information here on the screen. Should you be interested in a consultation with Boyd on his all of his services and what you may need. Again, maybe you already have a will, maybe you already have a trust, maybe you want a second set of eyes, a checkup on what you already have to make sure it's legit, falls into the line and the eyes of the Social Security Administration for a special needs trust, or maybe you just need to get started. But certainly feel free to reach out to Boyd directly. And again, Consolidated Planning Group here. So again, we're on the financial side. So what we're able to do is we're able to do a holistic financial plan. We're able to help you identify what are the future care costs, estimating the future care costs for your special needs child. We're able to run all of the reports on retirement and what you'll use in retirement and be able to estimate what will be left over. And we're also able to do a comprehensive Social Security analysis of when to take benefits, and especially considered if you have a disabled adult child under your record, because there's a lot of nuances to that. And an additional nuance to that is if you have a spouse that doesn't work. So if a spouse is drawing off that record as well. So again, we're happy to help you any way that we can, and we are super happy that you guys joined us today. Thanks so much, everyone.
Thank you so much, Allison and Boyd. I appreciate so much you joining the Fort Bend Center. Take care. Thanks again.
Have a great day.
All righty.